We'll call to order this special meeting of the Conejo Open Space Conservation Agency, April 29. And to start, would you join me in the salute to the flag, please? Ready to begin?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. May we have the roll call, please?
Vice Chairperson Bill De La Pena, absent. Director Fox?
Here.
Director Gibson?
Here.
Director Jacobson? Chairperson Skay?
Here. So we have a quorum, and we do expect Councilmember Claudia Bill De La Pena may be joining us a little later. I have no speaker cards on public comments, and just so the audience knows, this is a special meeting, and so any comments would need to be directed to the agenda item at hand, the public hearing. Since there are none, let's go straight to the public hearing. And I do also want to introduce our new recording secretary, Lilia Vaudreuil. Lilia Vaudreuil, thank you very much for being here. And also would like to welcome Candace Hong, Assistant City Manager, who's sitting in from the City Manager's office in our Cosca meetings. Lilia, would you please read the item?
Advertised as required by law, is hereby open to consider agenda item 4A, Introduction of Cosca Ordinance 01-2009, an ordinance of the Conejo Open Space Conservation Agency, Cosca, establishing Cosca open space rules and regulations.
Thank you. Manager Ford, I believe you're going to give the staff report.
Thank you, Chair Skay and members of the board. Good evening. I'd like to direct your attention to the screen for a PowerPoint presentation. As you all know, and as I described at the last meeting, Cosca does not currently have its own ordinances. Currently, the rangers and Cosca staff cite CRPD and city ordinances that apply to open space. But recently, the city attorney recommended that Cosca adopt its own ordinances before we notify property owners of apparent encroachments onto open space. And in addition, there was a general recognition that as Cosca has matured as an agency, it does make sense for us to have our own ordinances as opposed to using ordinances from other agencies. So at its March 11th board meeting, the Cosca board directed staff to draft a Cosca ordinance derived from the city and the CRPD ordinances. As a reminder, according to Cosca's Joint Powers Agreement, Cosca has, and I quote, any and all powers authorized by law to the parties hereto, which are the city and CRPD, relating to the acquisition, regulation, that's the key term, management, preservation, and disposition of open space real property. So pursuant to the board's direction at the last meeting, Cosca, city, and CRPD staff worked together to draft the proposed ordinance contained in your packet. The proposed ordinance has 51 sections in 5 chapters, and it incorporates all of the city and CRPD ordinances that relate to open space. And this includes CRPD ordinance amendments made on March 12th, 2009. We needed to make some minor modifications to the CRPD and city ordinances where necessary to adapt them to Cosca. Of course, we had to change, for example, if we were starting from a CRPD ordinance, we would need to change the authority from the CRPD general manager to CRPD general manager and the city manager, as those two people are Cosca's co-chief executive officers. And in addition, several existing Cosca policies were also incorporated into the proposed ordinance. Not all Cosca policies are applicable and are not all suitable to be made into ordinances, but several were. There are several notable differences from the existing CRPD ordinances that I'd like to bring to the board's attention. And I should also point out that the majority of the proposed Cosca ordinance is based on the CRPD ordinances. There were only a couple of city ordinances that were used in this process, and probably 90 to 95% of the proposed ordinance is derived directly from CRPD ordinances. However, we did add an exemption to Cosca's vehicular trespass section, which will allow disabled persons to use single-rider electric motorized vehicles for recreational purposes. And for the purposes of the Cosca ordinance, a disabled person was defined as exists in the California Motor Vehicle Code. In addition, we designated the killing, harming, or removing of animals from Cosca open space as a misdemeanor instead of an infraction. So in the CRPD ordinance, harming an animal is listed as an infraction. However, in the CRPD ordinance, harming or removing vegetation, geological features, or archaeological features is a misdemeanor. So in the Cosca ordinance, harming or removing vegetation, archaeological features, geological features, and animals are all a misdemeanor, which provides for uniform treatment for all of these resource damage violations. And finally, the proposed hours for Cosca open space in the draft ordinance are sunrise to sunset, whereas in the CRPD ordinance, the opening and closing hours for open space are listed as 7 a.m. to 7 p.m. or as otherwise posted. And the Cosca ordinance also has the exclusion for the otherwise posted. We made this change to allow for what we know is common use of the Cosca open space for early morning runs or early morning dog walks or summer evening hikes before sunset. And the proposed Cosca ordinance also establishes a Cosca-specific fee for filming on Cosca property. So currently, CRPD filming fees are charged for filming on Cosca property, and the fees go to CRPD. However, if the board adopts the proposed ordinance, staff will draft a Cosca filming fee structure for the board's consideration at a future meeting. And if that's implemented, then the Cosca filming fees will then go into the Cosca Trust Fund, which is a Cosca board-controlled fund. And as we mentioned at the last board meeting, but it's important to reiterate that in the future, to avoid confusion by the public in terms of what rules and regulations apply to open space throughout the city, because often open space ownerships are adjacent to each other and there's no property line marked on the ground, and to the public, they're not aware that they're passing through different ownerships of open space. If the all the ordinances related to open space at CRPD, the city, and at Cosca should be amended in parallel to ensure that they remain consistent. And with that, the staff recommendation is that Cosca ordinance number 01-2009 be read in title only, further reading be waived, and if no objection, introduced. And I would also like to call your attention to the supplemental packet which you received, in which we had a couple of changes noted, which were clerical errors. At the end of subsection 223H, it's missing a period, and that should be added. And also, at the end of section 227, we should change section 105 to section 106. In addition, I believe the city attorney has noted 2 other errors that he'd like to call your attention to.
Yes, thank you. Also on section 202 on page 9, subdivision H, it should read license plate instead of license place.
That's again in subdivision H on page 9. Also on page 19, in regards to the filming ordinance, section 241, subparagraph B, the paragraph should actually read a certificate of insurance naming Cosca as co-insured on the day or days of filming with the limits of not less than $1 million for general liability and $1 million for property liability, and then continues on as it's previously written. So again, it's just not less than $1 million for each general liability and for property liability.
And I did also want to call your attention to the one public comment which we included in the supplemental packet. And with that, staff are available for questions.
Questions of staff? Director Fox?
Just more of a comment that I think you guys use some good common sense with respect to the hours in particular. They're having, run in the trails a lot of times. It didn't, we're almost not enforcing what the rules were, particularly in the early morning, and then to reflect daylight savings and people using the trail system in the early evening. So I think that makes a lot of sense. And then the other one, in terms of the discrepancy between the Park District and Cosca, it seems to me that a misdemeanor for serious violations out there makes a lot of sense. I don't know what that carries, but I'm assuming it's a higher level of
Penalties.
penalty. Exactly.
Right. An infraction is fine only. Misdemeanors can have for each count up to $1,000 per count, plus up to 6 months in jail per count. The other issue with misdemeanors is actually I can use it as a way to get probation. So sometimes when we have to have additional work done or corrections made, if we have it as a misdemeanor, we can get probation. If they do not correct those problems within a certain time frame, I can go back to court much easier instead of having to refile something and bring it to the judge's attention. And that's when the judge usually just says, if you don't fix it within, let's say, 30 to 45 days, you're going to be going to jail. And so that's one of the reasons why that tool can be used.
Yeah, I'm just curious. In terms of patrol, particularly at night, I know there's roads that go through. I'm speaking, like of Wildwood, for example, out there. Is the open space? Is there some type of patrol mechanism in after dark with the rangers, so they all go home and we only respond on a complaint?
Thank you. If we have issues that are becoming apparent, we can respond to that by setting up some overtime and responding to that. It doesn't happen very often.
I was thinking more in the summer months when the kids are out of school, it's warm out, going back in there and doing what teenagers do.
Exactly. We've done that once or twice. We've also done some patrols based on fire prevention efforts during fire danger periods. It's when it becomes evident that something needs to be done, we'll make arrangements to try to do that.
All right. Thanks.
Other questions? Director Bill de la Pena.
Thank you. Good evening. I missed just the first portion of your presentation, but I would like to follow up on the hours as well. And is it my understanding, and please correct me if I'm wrong, if I'm out there past sunset walking my pet, would that, and somebody turns me in for doing that, is that a misdemeanor? That is punishable by up to $1,000 fine or whatever money amount was mentioned?
The violation of that section is only an infraction, not a misdemeanor.
Can you repeat that, please?
The violation of the section about hours of use is an infraction and not a misdemeanor.
It has been my observation living adjacent to open space that people are using the park, not the park, but the open space before sunrise and after sunset. And obviously nobody complains unless you have motorcycles going through and doing all kinds of stunts in darkness with their lights on. Is it realistic to have such a policy with sunset and sundown when we know that people are actually using the open space before and after that?
by having a regulation that deals with times of use, that gives us a tool to use. It can be a deterrent for inappropriate activity, and that's our biggest concern is when we have inappropriate activity. Issues of safety and inappropriate activity are our primary concern, and that's what I think the regulation focuses upon.
Should there then not be? I'm sorry. Go ahead.
I was going to say, excuse me, that time frame is actually consistent with the MRCA guidelines as well. They've adopted exactly the same guidelines. And just to let you know, as a prosecutor, as a litigator, I'm trying to use common sense for a lot of these things too. So when I get a case, there are cases that I actually reject just because it's silly, if you will. So, and another issue that you need to know is that it is complaint driven. So it's not like we are patrolling, going out there, watching everybody. It's got to be more if we have the complaints. And frankly, I think you've already pointed out that the complaints are going to be when someone's riding a motorcycle at midnight and someone hears that noise and they're concerned about that. That's where they're going to be the kind of response where we're going to be using that. But as the officer said, it's also just a tool to kind of remind people, hey, there is some rules here that you need to abide by.
You mentioned the MRCA. What is the National Park Service regulation? If I'm sure they have one.
They do have one specifically for the Santa Monica Mountains National Recreation Area. Their regulations are that the open space is open 24 hours a day, except parking lots with a gate are open only from 8 a.m. to sunset. And they have a specific notation in their regulation that states the reason why they have adopted these restrictive hours for the parking lots is to deter underage teen drinking parties, specifically listed in their regulations.
Should we then have, and it may be in here and I may have missed it, could there be a provision then instead of setting specific times in terms of sunset or sundown, provision for loitering, if that is what we're concerned about?
All I would say is loitering is actually a more difficult thing for me to actually prosecute than this would be. Loitering has a lot of history with it, and I actually might be a little bit more concerned about trying to go after somebody for that problem. I think with other code sections that we have to our disposal, we can actually, if there's going to be a violation there besides the one of sunset to sunrise violation, we would have other resources or other sections that we would probably be applying, like drinking or smoking.
Or other inappropriate activity, as
correct
was mentioned.
Correct.
I'm just speaking as someone who has witnessed that over the years, and I'm sure I'm not the only one, but there are definitely activities, and the ones I've witnessed are not all inappropriate, that go on at 9 o'clock at night, 10, 11, midnight. Happens on a regular basis, particularly during the summer months. So I'm just questioning whether having sunset, sundown provision is realistic. Thanks.
Director Gibson.
I think as Chief Ranger Kinney indicated in response to Mr. Fox's inquiry, how we dispatch security, without having a provision like this, it would almost be incumbent upon us then to possibly start looking to increase our security beyond, normal shifts to 24 hours. And again, I think as the city attorney's office said, they have the ability, when their complaint is registered, to judge the merit of the complaint. And I think from that standpoint, if people are doing things and whether it's walking their dog at 9 o'clock or, putting a telescope up in a dark area, those are, unintrusive, events. They're not out there 4 or 5 kids riding mountain bikes or somebody on a motorcycle, and I think it gives a tool. And I think that's what I am hearing from the city attorney's office, and what I've also heard from Ranger Kinney on this is that because if we go to anything else, then it's going to be incumbent on us on how do we enforce it.
and it seems to work right now. So if it's not broken, don't fix it. So, and on the advice of the city attorney and advice of Glenn, I think it is appropriate. I did read the one letter, and it's interesting that the person complaining is a person that, wanted to limit activities at open space and other things. So, you wonder sort of what people are thinking. But it's sort of a self-policing thing to a degree, and if it becomes a nuisance, we can respond to it. So I support it.
Director Jacobson.
I think we have to provide the mechanism, should the need arise, for the rangers and the city attorney to enforce and take appropriate action. They wouldn't do so, I think, in a haphazard manner. I think that they are utilizing a mechanism that has been set up for them as the need arises. And therefore, if people are not being obtrusive or having other problems or in violation of other parts of the ordinance, it's acceptable for them to be there for some reasonable time over and above the hours specified here. But if in turn there is a problem, I think they need a mechanism whereby they can indicate that there's a violation not only of ordinances but the time restraints that would be called out in the ordinances. So I'd be supportive of keeping it the way it is.
I'll chime in here too. Someone who has written tickets. It's not staying on there. As someone who, in another capacity, has patrolled and has written tickets for after-hours violations in parks, it's not just being in the park after hours that triggers. It's like the tool, as you say, the thing that catches the ranger's eye. And if there are other events going on, then that's what's the more important violation. But it can all be written up, and that helps strengthen a case, too, if one is needed. And then another consideration that may or not be as important here, but it can be, is actually trying to discourage nighttime use, or a gentle discouraging of nighttime use, not only for the peace and tranquility of surrounding neighborhoods, but it also that's the time when most wildlife is using that open space, and we can coexist very well. I've had people say, well, you shouldn't let people in the open space because that'll hurt the wildlife, and I can say very truthfully, it doesn't, because they have all night to use that area, and that's the crepuscular times, or the times that probably they're most active. But, I don't see anything wrong with saying people, during sunset to sunrise, which is a pretty long period of time. So, and as you mentioned, Director Fox, safety is an issue too. I mean, when it's dark, there are more things that can go wrong. So, Manager Ford?
I did have one more point that I wanted to make about this, in that when I was working on putting together the ordinance with my colleagues, I researched a number of open space ordinances from a number of open space agencies and open space districts throughout the state. And I did a little tally, and by far the most common hours of use from all of those open space agencies are sunrise to sunset.
Do we have other comments or questions, or is anyone ready to make a motion? Director Bill Dillapin had a question.
Would it be, and this is a question for the assistant city attorney, could that be modified, that the wording of that particular provision, with the exception of certain activities, at the discretion of, to be determined at the discretion of city staff?
I think frankly, I'd have a problem with the vagueness issue. I mean, I don't have a problem if you, as a board, want to try to redefine that. That's your protocol. My concern is just to say we're going to modify it some way. One, I'm concerned about vagueness, and two, I'm concerned about how I could possibly apply it, because then I might be getting into a problem with subjective enforcement type of thing. And so I certainly don't mind trying to, right now, come up with some other language if that's your pleasure. but to put it just where we would try to say we're going to determine it later on, some other type of calculation, I'd have a problem with that.
Fair enough. Thank you.
I do note that the language is unless otherwise posted. So if there were a circumstance, for instance, where we know there's a main trail that is a mountain bike access between national park land and some other route, we could post it that way. And of course, the manager can also issue a permit or a written permission for any event, or if there's a hiking group that wants to take a longer period of time. So I think we already have a little bit of flexibility in that.
If I could just add to that, we do conduct nighttime hikes, correct, on Cosca property. The Park District does.
That's correct.
Moonlight walks, hikes, or whatever they're called.
There is a master exemption in this proposed ordinance that states that these ordinances do not apply to Cosca employees, CRPD employees, city employees, or events led by those employees. So a nighttime hike led by someone affiliated with Cosca or CRPD, this ordinance would not apply to that.
Okay, then I'd have to call you about twice a month to lead me on a hike in the evening. Or yes, I guess I could. I'm authorized to lead my neighbors on a hike. Okay.
Yeah, okay. Are we ready for a motion? Director Gibson.
Yeah, I'll make a motion that we adopt ordinance number 01/2009 to be read in title only. All further readings be waived, and if no objection, be introduced.
Do we have a second? Director Jacobson?
Not a second, because we discussed one item of concern only, and I had other areas of concern that I would like to have clarification.
Okay, so you want more discussion, but do we need a second on this motion?
I'll second it.
All right. And now would you like to make your comment?
Under Section 204, vehicular trespass, and this was an area that was addressed in the presentation made previously by staff. It indicated that there would be a concern and a response to single rider electric motorized vehicles. And I guess the concern I have, and I understand the ADA requirements and part of the appropriateness of them pertaining to the use of our properties, but the only electric motorized vehicle, unfortunately, that I have seen was a picture of one which looked like General Patton's tank. And I guess the concern I have is that we not allow anything that is motorized unless it is approved for use by the appropriate staff people or the general manager or someone. I think there's a subtlety that we've seen in the past on ADA requirements being applied to ramps as to the degree of slope, the width, and what have you. And should we allow use of certain vehicles which may be wider in their tread than our existing trails, are we then opening up the requirement that we modify our trails to meet that particular access requirement for the motorized vehicle, either by width, surface, slope, or some other requirement? And therefore, I'd like to see that whatever motorized vehicles have been considered for use in the past or may in the future be considered, that they be approved for such use by an appropriate staff member.
Do you have a comment on that?
Yeah, and Director Jacobson and I had a conversation earlier today about this issue, and I think, there are, I think, scenarios that any of us could envision that would perhaps be abused if someone were inclined to do that. And I certainly believe that if that were the case, that staff would react quickly to try to address whatever those issues might be. I think in discussing it amongst staff, we were comfortable taking, somewhat of a progressive step here and trying to open up the open space to, and I think what comes to your mind is sort of a motorized wheelchair of some kind, but I do know exactly the photograph you're referring to, which is this large sort of chair on these tracks that you could imagine it chewing up trails and brush or something if it were improperly used. But I think if this board is willing to kind of maybe take a little bit of a risk with the idea that we'll monitor it very closely, and if in fact we do notice any kind of issues or problems because of the use of motorized vehicles, we would act quickly to kind of address that and regulate it in some way.
Okay.
Thank you.
It is a little out of order since we have the motion, but since we only have one, we have a public speaker card from Mark Langton, and I assume this is on the particular public hearing agenda item, Mr. Langton?
Yes.
Okay.
I apologize for being out of order, but as you know me, I pretty regularly do that. I'm Mark Langton in Newbury Park. I'm also the chair of COSTAC. I had a thought as you were discussing Section 219 that perhaps could solve the problem. I understand the Assistant City Attorney's concerns and all of the concerns in regards to sunrise to sunset. Sunset to sunrise. But I was thinking that perhaps if you could modify or somewhat change this paragraph to say something to the effect of, and I'm probably not saying it correctly, but something to the effect of activities that are deemed appropriate by the park district relative to already existing accepted uses, and that therefore you are setting forth a set group or list of accepted activities, and you could therefore even perhaps list unacceptable activities. But if you say, for instance, hiking is allowed during the day and hiking is allowed at night, and on and on in terms of the things that people might be going out and doing in the open space during the day as well as at night. So that, I don't know if that's making as much sense as I thought about it when it first popped into my head, but it just seems like there can be a way to not be so subjective and not be so arbitrary about it. And if you say activities that are accepted during the day are accepted at night. That was my comment.
Madam Chair, just really quick. The motion's already been made. I just want to give you this, it's the board's pleasure, but if we make any changes after this point to this, we have to actually redo the motion just because we have to make sure we incorporate any changes before we introduce it for the next stage.
Right.
All right, so if any changes are to be made, then this motion has to be redone.
Okay.
We're still discussing the motion.
We're discussing the motion.
Okay. I guess, in response, and I can recognize what folks are trying to do, but I just from my perspective, both professionally, trying to rescue folks that really use poor judgment. We're in a nice, reasoned environment here, but I can tell you, and I'm sure the ranger would tell you that people do some incredibly stupid things that you would just think, how would anybody think that was safe to do? I think we need to discourage people using our open space after dark. I recognize folks do it. They go out there with flashlights and moonlight walks even when they don't have staff, and in most cases, there's no bad outcome. But I can tell you that that's why I like the change in hours. They make sense for somebody who wants to go for an early morning run, or maybe gets caught back there a little after dark, that type of thing. But I think as a policy, we want to discourage after hours use, because more often than not, you have a bad outcome. And then for the folks that have to be the first responders, it gets very complicated trying to find somebody way back in the open space when they've fallen down a cliff. They're unable to, you can give you a lot of scenarios. So I think we need to be very careful. And then just in response to what Patrick was saying, I think in terms of enforcement and that, I think less is more. The language is very well written. It gives the city attorney the latitude to use their discretion. but it also puts some parameters out there that for reasonable use of our open space. So I'm going to, encourage us just to stick with the language.
Thank you, Director Fox. I have a question. All right.
I do have a question. Currently, we don't have any restrictions on the hours or use? We do? Okay.
7 to 7.
So it is 7, just like the park districts then. Okay, and so for the last, who knows how many years, a couple of decades, we really haven't had any, we've had a couple of emergency calls, obviously. Some of them were very, very serious, but they happened during the daytime, if I recall correctly. Do we have any instances of where nighttime, in all these years that Cosca has existed and managed open space, where we needed to call a chopper at night?
Yes, we have. We've had search and rescue issues where we've had people missing, and it's constituted search and rescue people brought out, including helicopters and that kind of thing. It's happened, I think, 2 or 3 times in the tenure I've been here, as well as issues related to vehicle activity in open space where accidents have taken place or they've gotten stuck, and it involves people coming out and securing vehicles and transporting people.
And those were nighttime events?
Mm-hmm. Yes.
Okay. Thank you.
Director Gibson.
Again, with all due respect to, the speaker and everybody else, the comparison was, why can't we use the National Park Service standard? Well, they're a 24-hour, 7-day-a-week, 365 organization. They're set up for different things. We're not. I agree with Director Fox. There's so many what-ifs out there. From the environmental standpoint, I agree with Rory on this, is that, we do need to leave some tranquil activity time, and it's the night time for the animals and the sensitive species. So I think the ordinance is well written. It's, whether there's been problems with 7 to 7 in the past or not, I don't know. But I think it's prudent to go forward the way we got it. If it needs to be changed for some, substantive reason down the road, we can revisit it.
Director Jacobson.
Repetitively, I hear referrals to what does the National Park Service do or some other agency. I think this agency and the city is unique and needs to have an application of regulations and ordinance which are tailored to the needs of the community and not necessarily based on other organizations. I tend sometimes to resent the fact that, that's not the way the National Park Service does it. Well, I don't care how they do it sometimes, because I think we respond to the uniqueness of our community, and if it parallels the other agencies, fine, but if it doesn't, but it's appropriate for our particular agency, then so be it.
Okay, thank you. Are we ready to vote? No other questions or discussion? Yes, Director Bill De La Pena.
I'm in favor of adopting everything, and I would like to, however, record a no vote on Section 219 based on my own experience with, over the years, with many people, hundreds, if not thousands of people who use the park after sunset and before sunrise. Thank you.
All right, may we? More discussion?
Point of order. Can the vote be with the exclusion of a section by one of the people voting for?
My brain's torn on right now. I don't have the answer to that, but I think I want the motion to be, make sure we're all clear, the motion is approving the ordinance to be read in title only, further reading be waived, with the corrections previously announced, and if no objection, introduced. That is the motion.
Yes. So I guess your option might be, we've for the record, they will be in the minutes.
She made the record.
So, but I think we have to vote yes or no on the whole thing, or you could abstain.
And Mr. Heher, then how would I record my opposition to item 219?
I think you've already done it.
I've done it, and that will, the record will reflect that. Okay,
Correct.
Then that will be a yes vote.
Okay. All in favor of the motion as stated, please say aye. Aye. Any objections? Any abstentions? Okay, thank you. This was the first reading, and this will come back again at At the May 13th meeting? Okay. Are there any board member comments?
I believe there's one more staff report.
I'm sorry, Ms. Ford?
Just have a very brief item to update the board on the status of our public workshop for the update to the priority list of areas for potential purchase as open space. On Monday, April 27th, we mailed the flyer about the workshop, which I believe we also provided a copy of that flyer to the board. We mailed this flyer to 200 entities, which include HOAs, conservation nonprofits, as well as interested individuals. We also emailed the flyer to our mailing list, our email list, and we sent a press release to the local papers on Thursday, April 23rd, about the workshop. And we will be posting this on our website, and the flyer will be in the trail kiosks by the end of this week. The public workshop will be held as part of the regular Cosca board meeting, and we will have several other regular board agenda items that evening as well. And because of the desire to have it televised, and because the boardroom will accommodate up to 65 members of the public in a meeting, we are going to hold the public workshop here in the boardroom.
Okay. Thank you very much, Ms. Ford. So, last chance for board member comments. Otherwise, we are adjourned until Wednesday, May 13th in this same location. Thank you.